We are on the record in the matter of President Donald J. Trump et al. Versus J. Ann Selzer et al. CBCB 069420. This is the time and place set for hearing on the motion to dismiss in this case. Present here in the courtroom today are counsel for all of the respective parties. Prior to coming on the record today, the court spent a couple of minutes speaking with counsel about just the logistics and the manner in which we were going to proceed. We are now ready to proceed with oral arguments. As such, I will first turn to counsel for defendant Selzer and allow you to make your arguments. You may proceed.
Good morning. I'm Corn-Revere and Ann Selzer.
Just a second, let me make sure that you're turned up as best we can. Give me just 1 second, I apologize.
I'll sign for that.
If you can, I would appreciate it. Let me try to speak now. If you can, yeah, hopefully that will pick up a little bit better.
Thank you, Your Honor.
There you go. You may proceed.
Good morning, and support. I am Corn-Revere for the defendants J. Ann Selzer, Selzer County. Your Honor, Ann Selzer is with us in court today. I'm going to introduce her. She's as close to counsel as we can get. She is here for the argument. Your Honor, there's an old saying that everything looks like a conspiracy to those who don't know how anything works. And that sums up this case in a nutshell. The plaintiffs do not understand how that works, so they try to concoct a case. They petition with campaign slogans and conspiracy theories. The issue of this motion is whether any of that adds up to a recognizable legal claim. It doesn't. In this particular case, it doesn't belong to this or any court. It's based on legal fake news, not when you recognize a claim. And all claims are barred both by the First Amendment to the United States Constitution and by Article 1, Section 7 of the Iowa Constitution. And even if not constitutionally barred, these are not valid claims either under the Iowa Consumer Fraud Act or at common law. Plaintiffs are going to pretend to be the elements necessary to support their claims. And even if we accept all of the plaintiffs' baseless factual allegations, as one does in the motion to dismiss, all of the claims are barred as a matter of law. This case must be dismissed with prejudice. Now, just to lay out where we're going on this and save a little time, I mean, this file division of labor, I'll be starting with the First Amendment issues. I'll be talking about the individual claims for from the Southern Amendment, but both of the arguments on the Iowa State law claims in the law will be handled by Mr. Klinefeldt.
Just 1 second, Mr. Corn-Revere. Do we have the other Belin? I'm going to do something. We're having a difficulty. It's just not picking up quite enough. So I'm going to have Becca give you a different microphone here.
Okay.
If you could put that on your lapel, I would appreciate it. And hopefully that will pick up a little bit better than the one that we have currently. And just ask you to speak up as best you can. I appreciate it. Yeah. What you, yeah. Yeah, you go ahead and take that, Becca. I appreciate it. See if that is that better? Is that better? See? I'll turn it up. So I believe it is. So thank you very much, counsel. I appreciate it.
Sure.
Proceed.
Starting with the constitutional issues. The First Amendment of the Iowa Constitution bars these claims entirely. There's no such thing as a claim for fake news. And a few cases where news is alleged to be fraudulent have all been immediately dismissed. We cited those cases at the beginning of our motion to dismiss. And they've never been responsible from the plaintiffs. Now, and as a matter of fact, I've been puzzled over what plaintiffs think is their best case, even in support of the theory, in support of these claims. And I'm still scratching my head, and perhaps Mr. Ostergren will enlighten us very good time. is not in one of those categories of unprotected speech, and claims are simply alleged false like that has been compromised. The claims here are based entirely on three false propositions. First, plaintiffs claim that election polls are commercial speech because they are done for profit. Second, they claim that election polls are not news, protected by the First Amendment. And third, they claim there is no state action and therefore no First Amendment issue because this is private litigation. These propositions aren't just wrong, they're not even debatable under established law. First of all, unanimous authority holds that for-profit speech doesn't equal commercial speech and is fully protected by the First Amendment.
Let me say this, Mr. Corner. In your research, have you come across any case law that would indicate a similar fact pattern has been determined to be commercial speech?
No. And as a matter of fact, even the cases that the plaintiffs cite that they say there are commercial speech describe the difference between for-profit speech and commercial speech and say that there are simply no conflict cases.
Now, one of the things that the plaintiff, and I'll ask the plaintiff about this, it cited was the Cincinnati case.
Yes.
And that case, at least in part, said that basically anything in a newspaper was considered for profit or for it implied, I guess, maybe it is potentially commercial speech. It's my understanding, though, that you disagree with that reading of Cincinnati. Is that correct?
I completely disagree, but as a matter of fact, it completely miscites that case. Page 14 in their resistance brief, they cite that case with the one snippet of the case that says that much of the information in the daily newspaper is commercial. That's right. Newspapers are protected, include advertising, they are for-profit businesses. But the point the court was making in that case is that nonetheless they are fully protected. The issue of discovery methods was whether or not the city could regulate news boxes on the street that would go entirely to commercial matter. And the point the court was making in that statement was that it doesn't matter if you're trying to regulate placing the news boxes, even daily newspapers that have news in them have a lot of ads in them. You can't regulate them just because of that. So discovery network stands for exactly the opposite of the proposition for which the plaintiffs are fighting. And that's true of the other cases where they cherry specific lines from cases talking about commercial speech. The job is a little easier when you get to a claim about whether or not election polls are protected because they cite no cases to support that proposition. In fact, there are no cases saying that polling is not protected as coverage of election. We cited an uncertain case of David versus Monroe, and basically the plaintiffs simply cite their own assertions for that proposition.
Other than the Donnelly case, which obviously we'll talk about at some point, is there any other case law involving a free speech challenge to polling in particular?
Yeah, the David versus Monroe is one that talks about that. And that's where the court actually discusses why polling is protected by the First Amendment. It's Belin protected because the act of polling involves talking to people to find out what the voter sentiment is, and then publishing the poll is the election news. And so there is that. There are very few cases that go into that, by the way, Your Honor, because it's such an obvious proposition that it is a question. It is no wonder that the plaintiffs didn't have a law to cite there. The third fallacy that they try and use to justify their claims is to say that there's no state action here, and therefore the First Amendment doesn't apply. Ironically, they make that statement on the same page of the resistance, where they cite the New York Times versus Sullivan, which is a paradigmatic case for those kinds of limits on private lawsuits, and why the First Amendment applies. And as a matter of fact, that case is comparable here for a variety of reasons, because that case emerged from a campaign by Southern officials to try and close down news coverage of the civil rights movement. And they were trying to use private litigation as a vehicle for doing that. And the Supreme Court, in fact, said, no, you can't use those private lawsuits as a way to speech. And it established state action. And we cited a number of other cases as well. It also reinforced that point. The reference to Sullivan is relevant for another purpose as well, because the plaintiffs here are using essentially the same tactics as in Sullivan, but they're simply trying to use the vehicle of claiming fraud as a way of doing that. That's something that is also foreclosed by reason of Sullivan. For example, the Supreme Court in New York County Sullivan said that the experience the United States had with the Sedition Act described the central meaning of the First Amendment. It first crystallized our national awareness of what the First Amendment means. And what it means is the government doesn't get to penalize false newspapers. That's what that case was entirely about. And what this episode with the Sedition Act was all about. And in fact, when the Supreme Court started formalizing the First Amendment jurisprudence in the 20th century, the first case dealing with press freedom was near Minnesota, where the state was trying to penalize a newspaper called the Saturday Press that was simply described by its detractors as a partisan rag. It was nothing but lying and scandal from top to bottom. The Supreme Court said no. Trying to censor even that newspaper was considered to be the essence of censorship. And the court drew the line and established the first major precedent in protecting the press. Here, what the plaintiffs are trying to do is to cancel those bedrock rules and say they can simply go like fraud and get around the First Amendment.
Let me ask you this, maybe I'm getting ahead of you a little bit, but assuming for a second that I would determine that this was not commercial speech, First Amendment clause, does that dispose of all the claims? I know you've said in your pleadings it's not a matter of immunity, but from a practical standpoint, does it actually extinguish all the claims?
Well, ultimately it does, but establishing that the First Amendment fully applies is the first major premise here.
Okay.
The second premise is one that was established with case law again through the 20th century. Cases saying the exceptions to that rule are few, narrowly defined, and carefully guarded. You can't simply expand the unprotected categories of speech. I just make the point that fraud is unprotected speech. Of course it is. That's one unprotected category. You can't simply call something fraud and make it fall into that category. That's what the Supreme Court said in the Mariannette case, that simply labeling that doesn't cancel First Amendment protections, which is what they're trying to do in this case. As Sullivan said, we can't simply refer to mere labels of state law as a way around the First Amendment. And even during that period, during the time when Sullivan was arguing, there were attempts in other cases to use state business law to target civil rights organizations. Those were shut down as well because they were being seen as ways to try and bypass First Amendment protections. In terms of trying to redefine fraud, there have been various attempts over the years that we talk about in our meetings. The key cases that we cite there are United States v. Alvarez and two arson cases from the 8th Circuit. Those cases explain that you can't simply expand the boundaries of fraud. And most pertinent for this case, they say that you can't expand it to cover election coverage for political speech. Those are the things that the First Amendment protects most. First Amendment protections are Arizona. And the Alvarez court said trying to expand the definition of fraud would give the government a broad censorial power unprecedented in the Supreme Court's cases or in our constitutional tradition. This was the thing that the courts were worried about in terms of expanding what the government tried to do under the Sedition Act. The Iowa Supreme Court, in Virgin v. Des Moines, said we need to look no further than the Sedition Act in 1798 to further understand that unscrupulous individuals would use the force of forcing government to censor their critics and retain power. Again, that's exactly what is the attempt here. So far, there has been no real response to the analysis in either Alvarez or in either of the honesty cases. They're saying that you can't just label an action for fraud and quote carry the day. The court said the alleged fraud without the essential elements would support strict dismissal. That's straight from Madigan versus Belin and Associates. And the court in Madigan explained why that's so important and why it's a constitutional issue and not just an issue that relates to the individual state law claims that Mr. Klinefeldt will talk about. The court in Madigan said that the exacting proof required to show fraud exists to provide sufficient breathing room for protected speech, and it went through to talk about the particular elements and why they are connected to constitutional protections. The problem here is that even with notice pleading, you can't create a court that doesn't exist, and you can't create duties that otherwise aren't recognized in law. There can be no misrepresentation in the case for Ann Selzer, where there's never been a representation, there's never been any contact between Ann Selzer and any of the plaintiffs. No relationship that would require some sort of duty to them or to the general public. As I say, there's no communication about anything. That, I think, covers the main issues on the First Amendment question. And I'll just say a few things about the state law.
But before you do, let me back up and ask you about the commercial speech exception that's being argued by plaintiff in this case. Obviously, you contend that it doesn't fit into the category of commercial speech. I think you depend on the Central Hudson Gas and Electric case.
Yes.
How does that case distinguish what we have here from commercial speech? What do you hang your hat on in that?
Well, Central Hudson is a 1984 case that defined the commercial speech doctrine and made it clear that the difference between commercial speech and everything else is that commercial speech is speech that doesn't involve a proposed commercial transaction. Essentially, we're talking about advertising. Right? We're not talking about even where a newspaper includes advertising, as the Discovery Network's case made it clear. The inclusion of financial support for advertising doesn't convert the newspaper to commercial speech.
No, it's my understanding that the plaintiff, I'm wrong on this, but the plaintiffs have argued essentially the poll was used as tantamount to advertising in this case to entice people to buy paper. Does that deal with the problem of Central Hudson Gas?
No, not at all, because that would extend the commercial speech doctrine to all newspapers, all media that are advertising supported. The argument can always be made that they are simply putting out whatever they're putting out, as I said before, for the purpose of selling newspapers, for the purpose of generating viewership. But that would simply cancel First Amendment protection. The court's been quite clear that that isn't sufficient. And even if you've got commercial speech and regular speech interspersed, when it's intermixed that way, it's protected as regular speech. And even if you could stretch the definition of commercial speech to apply in this case, which it clearly is not, you would still have to meet the elements of why it's false and why it falls in the category of fraud. And as Madigan explained, those requirements are constitutionally required to involve that First Amendment breathing space. So nothing about this commercial speech argument is remotely close to mine.
So when you say that the requirements of Madigan, you were referring to the requirements of malice? Is that in particular?
No, that would be the defamation category. Those were the requirements established by the Supreme Court in New York Times versus Sullivan, which is the specific standards for defamation.
Right.
And I should say, the court in Alvarez went through and said, you can't mix and match these theories. You can't say we're going to cite a few lines from defamation cases and then apply them to false cases. Generally, you can't take a few lines from fraud cases and then expand that to expand category of fraud. The court has been quite emphatic about how sterling and dangerous it is if you go about the business of trying to redefine or expand those existing categories.
So tell me about the state claims, or to the extent.
Yeah, just a few words on that, because Mr. Klinefeldt is going to cover that in May. The Iowa Consumer Fraud Act claim, I mean, it is a claim that fails at the threshold because political polling, election polling, is not commercial merchandise within the meaning of the meaning of the law. That merchandise, according to Iowa Code 714H2, is merchandise offered for sale or lease, sold or leased, primarily for personal, family, or household purposes. That's not an election poll. So right out the gate, that claim fails. We say in our papers the other reasons why it simply doesn't apply to this situation. But once you break that nexus, the law doesn't apply and should be dismissed under well-established law, even under notice plea. The fraudulent misrepresentation claim, we showed up plaintiffs who failed to allege that for 6 of the 8 required elements of fraudulent misrepresentation. But the main problem is that plaintiffs misunderstand fraud as a concept. It requires a false statement intended to persuade the plaintiff to part money, property, value, and reliance on the statement. Nothing about Sullivan falls into that category. Again, it's like there's been no allegation that the Iowa poll was material to any claim or being used to induce any reliance on the part of the plaintiffs. The negligent misrepresentation claim also fails at the gate because there's no duty between a pollster and anyone else other than the people she contracts with. No one among the plaintiffs went to her for advice, didn't provide them with advice. The negligent misrepresentation is simply a shoe that doesn't fit. And we cited a number of cases saying that general news reports don't create a duty to the audience. So there's really nothing there.
To the extent, I've done some research, one of the areas I looked at was similar case law involving claims of weather, misrepresentation, things like that. It's my understanding, and correct me if I'm wrong, that to the extent that there's a duty, the duty is to generally the public and not to a specific individual, is what those cases often come down on. Is that correct?
That's partly true, Your Honor. And the main case I think you may be referring to is Grant versus Weather Channel, which was the case in Southern District Court where someone brought a wrongful death action against the Weather Channel saying that the forecast was wrong and therefore someone was killed at sea, and as a result, the Weather Channel was responsible for not providing accurate weather forecasts. Actually, it's a very close analogy to talking about election polling. And the court said a couple of things. One, that the duty simply did not exist, and for that reason, it broke the possibility of liability in that case. But it went on to say that if you try to impose a duty on the weathercaster to the audience, that would create unlimited liability. And so it was absurd as a concept, and it would violate the First Amendment to try and interpret it that way.
So those cases do, though, at least in part, deal with First Amendment claims.
They do, because they deal with the substance of the claim to begin with and conclude uniformly that there is no duty that can be enforced in an immediate context like this. But they also say, as sort of an additional part of the reasoning, is that if you were to interpret a duty in that way, it would be an intolerable burden on the First Amendment. The last thing I'll talk about, Your Honor, is that we requested a report to compel the plaintiff to show cause why there are or are not in compliance with Rule 1.413.1 of the Iowa Rules of Procedure. We tried to explain that this is a frivolous case in the beginning. We briefed, as you may recall from the stage here in January, the many frivolous cases in which the lead plaintiff has been involved. We pointed out in the motion to dismiss that they have yet to name a single case that supports this city. We predicted at the time that by the time we reached today, we would still not see a single case that
Is that where you hang? Oh, let me ask you this. What can you say, or do you believe that this is a good faith extension of the law as it currently reads?
No, and that's why we devoted a section of our motion to dismiss to say that there hasn't been any argument for extending the law here. And that was the point that the I was agreeing for in Barnwell versus District Court of Polk County, where it said that even in notice pleading, there comes a time when lawyers have to acknowledge what the controlling precedent is with candor and honesty, while showing reasons to modify or change the law. There's never been any argument by the plaintiffs that this court should change the law. They're simply trying to say, in their view, what the law is, contrary to unassailable precedent. And what's more maddening about that is that we have asked for explanations and have gotten none. We have pointed out there are no contrary cases on this very commercial speech and no response to that. And it would be bad enough if that were just happening in the case post June 30th of last year, where the complaint was filed in this court. But as Your Honor knows from the previous history of federal court, these same arguments were made over a year and a half ago. And there was a briefing exchange between the parties. The plaintiffs are well aware of this authority, and yet simply don't respond to it. So our suggestion is that as members of the bar, we owe a duty, and we are not asking the court to issue sanctions at this point. We're asking the court to require an explanation for how any of this can be consistent with Rule 114 or 413.1 of the Rules of Civil Procedure.
Thank you very much, Mr. Cornrevere. That we'll turn to Mr. Klinefeldt. Mr. Klinefeldt, two things. Make sure that microphone, put it on your tie if you can, if you get something a little bit better. And also, I forgot to mention this about this courtroom. Unfortunately, we can't cover up the windows at the very top, and so there's a spotlight that often will hit you right in the face. If you need to move a little forward, move a little back to get out of the sun, please feel free. That's, yeah, it's kind of a brutal part of this courtroom. But yeah, whenever you're ready to. You should be able to push that forward if you need to, or push it back.
Good morning. My name is Ann Selzer. I'm here on behalf of the Des Moines Register and USA Today. Along with me is my colleagues, Dave Yoshimura and Karen Gunkel, and the rest of the Faith Member team. And importantly, also along with us is Ed Larkin, who's the Chief Litigation Officer for the USA Today. Your Honor, I would first like to report that the death of the motion to dismiss in Iowa has been greatly exaggerated. I went back, checked the book, law firm Verizon every year, the Iowa Rules of Court. Sure enough, it's still there, 1421F. The following defenses of matter committee raised pre-answer and pre-answer motion, very distinct claim upon which relief may be granted. Not only does the rule still exist, but it gets used. As we cited for Your Honor, I think we cited almost 12.5 cases. Our hands eventually got sore from citing cases. We left some off. And the standard is clear. The standard is this. The claims must be dismissed if they are legally deficient and plaintiffs have no right of recovery as a matter of law. Plaintiffs rely here a lot on notice pleading, and we understand that's important. But what's also important to understand is that we've been at this now for over a year and a half. As Your Honor is painfully aware. This lawsuit was originally filed right after the 2024 election. We are now approaching on the next election. The petition, in some form or another, has effectively been filed in 3 different cases. And we have 42 pages of alleged facts. So we know what those are. We have 50 pages of briefing from counsel and their resistance. And so we know what the alleged legal support is. And the problem here is that there is no notice of claim when there is not a valid legal claim to be had. There's simply no notice of valid legal claims here. Even if everything plaintiffs say are true, which I know is the standard, they still cannot allege a legally valid claim. Many of the cases that plaintiffs cite on their notice pleading argument really deal with factual disputes. I don't have enough facts. You have to fill in enough blanks. I dispute the facts. And certainly while we would all disagree with some of the facts they allege, that's not the purpose of this motion, and that's not what we're here to talk about. What we're here to talk about is assuming everything they say is true. There can be no valid legal claim.
Let me ask you, before you launch into it, Mr. Klinefeldt, let me ask you a couple of questions. One, it's my understanding, and I think you brief on this, that the Supreme Court in Iowa has rejected the Iqbal-Twombly analysis of federal pursuits, correct?
Correct.
Strikes me as the Donnelly case, Judge Evinger in that case, they put a fair amount of weight on the Iqbal-Twombly analysis in coming to her conclusions on the dismissal of which are very similar cases or similar situations as here. Is that the correct statement?
Well, Your Honor, I think that there's really only kind of one issue where she may have relied on the plausibility standard, and that is, and I believe my colleague here has pointed out, regarding the Pearson article.
And she disregarded the Pearson article, correct?
She did. She rejected it because she said that it didn't have a valid factual predicate.
And
she did make sense.
And she hung her hat on the Iqbal-Twombly standard in doing so?
She certainly seemed to indicate that was part of it, but there are other reasons to disregard that. Okay. And again, that's not vital to our argument. We raise it in our brief because we take objection to that accusation that the poll was manipulated or manufactured in some way. It's rank speculation. I know that we cite cases in our brief that you can't simply, reference a footnote to your brief and then kind of indirectly rely on it. In other words, they say the poll was fake. And so there's other reasons besides the one which Abigail relied on to disregard that factual allegation. And we would suggest that Your Honor should disregard that factual allegation. But I believe that's the only time she relied on it.
Let me ask you kind of a different question before you get too far into your arguments on the notice standard. One of the things, and I'm not sure if it was the Selzer defendants or you that kind of implied that we should kind of take a fresh look at the motion to dismiss standard under 1.421 with the advent of Iowa Code Section 652.1, which is the anti-SLAPP legislation. That gives us some indication of the public policy that the legislature is wishing to promote. Do you believe a higher standard is required currently in a case of this nature, given the fact that there is both First Amendment issues relevant and the new kind of public policy argument that has come about because of this anti-SLAPP legislation?
We think it can and should inform the court, Your Honor. But we'll be clear. We know it doesn't apply here because the plaintiffs filed the lawsuit the day before it took effect. We understand that the anti-SLAPP statute has changed kind of the notice pleading standard for those cases. But I think what remains is that the legislature has clearly indicated a policy preference to be very cautious in lawsuits like this. And now there's a system set up, the anti-SLAPP statute sets up the system. But it highlights the danger of these kinds of cases. Luckily here, we don't need that higher standard. We're just filing a notice for the standard because this is not a fact case, it's a law case. And what you'll notice throughout, and my colleague, Mr. Corn-Revere, mentioned this, what you'll notice throughout here is a couple of things. There's a mixing and matching of elements that plaintiffs do, where they'll kind of ignore some things, or they'll separate an element, they'll try to rewrite the element. The second thing you'll notice is a lack of case law. Just as Mr. Corn-Revere pointed out regarding the First Amendment, you'll notice that in their info section, there are 0 cases they cite for the very part. In support of the fraudulent representation claim, 0 cases. In support of the negligent representation claim, they cite a couple of cases regarding the standard that we talk about as governing the support of the case. So I know we've thrown a lot of Your Honor in terms of briefing, and Your Honor has been very gracious in scheduling, and I know we just filed a reply brief on Monday, and that was voluminous. This is an important lawsuit. It's a lawsuit by the President of the United States against the largest newspaper in the country, and we take it very seriously. And so today, I'd like to be as practical as I can and make it as simple as I can. With regard to the First Amendment, I'll simply say this. I think Mr. Corn-Revere has covered it. I think we've covered it in a brief. It appears that plaintiffs have settled on a commercial speech. Mr. Corn-Revere has explained why it's not commercial speech. But the vast majority is something. And so, if that were true, if it were commercial speech, if plaintiffs were going to issue, the problem is they then turn the page and they forget that analysis in their arguments of the claims. And here's what I mean. That if plaintiffs were correct, and this was a commercial speech case, then under the Cincinnati case, they would be limited in terms of the act that they're suing about to something that is solely a proposal for a commercial transaction. That's it. But they forget that in the rest of their analysis. And so I'll talk about first the IFA claim and try to make that as simple as I can. Here's what I'll do. I'll just talk about what is the requirement, what are the allegations, and what are the reasons why it's ever been required. There are really sort of 4 essential elements of an IFA claim. And I know there has not been a lot of case law on the private right of action under IFA because it just came into effect in 2009. And as your Honor knows, our Supreme Court has identified that the state of Iowa adopted their statute based on Illinois statute, and the Supreme Court told us to look to Illinois for guidance in terms of case law, which is really helpful here because one of the cases that your Honor looked to, when we set a brief, when we talk about the reliance on the element that plaintiff's claim doesn't exist, is the triplex case. And on page 461, 462 It lays out the elements, the Illinois Supreme Court. And it says the elements are as follows. The act first have a deceptive act or practice by the defendant. Second, the defendant's intent that the plaintiff should lie on the deception. Third, the occurrence of the deception in the course of the conduct involving trade or commerce. 4, actual damages to the plaintiff. And 5, that those damages were possibly caused by the deception. First, let's talk about the act. The act that's alleged here, Your Honor, is there's several things that you can go under ICFA. Plaintiffs have chosen 2, unfair practice and deception. And what they allege is the publication of the article. Plaintiffs also argue that, well, it's not just the publication of the article, but we sort of speculate that it was manipulated or manufactured in some way. But it's got it. Here's the reasons why that's not being divided. And why there's no pleading, there's no discovery, there's nothing to say. First, the article is not an unscrupulous business practice, which is kind of a phrase that the articles have used to describe unfair practice. With regard to deception, it doesn't involve a false statement of fact. We said plenty of cases that it's a poll, it's a scientific opinion, it's not a statement of fact. And it knows it's not a statement of fact, but it's not as required for deception. It's a statement of fact regarding something that's material to a consumer transaction, right? Think of price or things like quality, and so forth. That's not being alleged, and it can't be. And as we talked about, we don't believe the owner should accept this allegation of manipulated manufacturing. But again, even if the owner doesn't matter, there's still no claim. The second element is intent. And this starts out kind of mixing and matching and regretting the law. Here's the actual requirement. Press defendant, they have to prove that press defendants intended the act to be relied upon by plaintiffs in connection with the sale or advertisement of consumer merchandise. So they allege that, well, the intent was drumming up political support for the Democrats. Here's the reason why that's not being defined. First, let's just talk about sale and advertisement for a minute, because I know there are other types about advertisement. They've effectively disavowed advertisement. If it talks about advertisement, sale, lease, clearly we're going to be talking about a lease here. Plaintiffs just rely on the sale. They're not saying the advertising. Here again, under Cincinnati, First Amendment problem. But just with respect to the sale, they didn't sell anything to these plaintiffs. And you have a First Amendment problem because it's not a proposal for consumer transactions. Second, let's talk about consumer merchandise, because that's another piece of the selling. As we pointed out in our opening brief, plaintiffs took a definition of consumer and a definition of merchandise and ignored the definition of consumer merchandise. And that was really important because in doing so, they read consumer transaction, consumer, anything to do with consumers completely out of the statute. Because the way that the private action is written identifies consumers as just a natural person. And then identifies consumer merchandise, as Mr. Corn-Revere explained, something primarily for personal household use. They excised that out and said, well, Donald Trump is a person, okay, and the newspaper was merchandise. But they didn't talk about consumer merchandise, which is the heart and soul of the Iowa Consumer Fraud Act.
Under the definition of the plaintiff's advanced, Mr. Klinefeldt, wouldn't virtually every podcast, every paper, every magazine fall under that definition?
Yes, and importantly so, you would rip apart the essential fabric of ICFA because ICFA is about protecting consumers. It's not about business-to-business disputes.
And you contend that there needs to be at least some degree of reliance or personal reliance on it as well, is that correct?
Yes, and that's again a separate element. But before we get to reliance on the intent, what they do is we talk about sale, we talk about consumer merchandise. But again, remember that the elements that press defendants intended the act to be relied upon by plaintiffs in connection with the sale or advertisement of consumer merchandise. And so here's what they do. Very much like how they split up consumer merchandise, what they do is they split that element writ large up as well. So they say, well, let's split it into two parts. Intent others rely on the act. And then separately talk about the act was in connection with the sale of consumer merchandise. They bypass the third one. And so then they say, well, intent others rely on the act, political split. That was it. The people relied on it, for political reasons. Nothing to do with consumer transaction. That's not what it's about. And then with respect to the act was in connection with the sale of consumer merchandise, they said, well, a general circulation newspaper can be consumer merchandise. And sure it can. It wasn't here. And as the case law we talk about, you have to actually look at the reason why somebody bought it here. But they completely bypassed the through line. They are not alleging that we did something that they relied on to purchase the Iowa Poll or the Des Moines Register. That's completely misleading. And that is the requirement. Third, reliance. This is what it's a little easy. Because they just say, well, reliance isn't required. And so we don't really have to say anything about that. To the extent that we do, all I say is polls can have impacts on elections.
I do want to make sure, though, to the extent that you're finding or arguing that the reliance issue is an element of the claim, that's based upon essentially Illinois case law, as my understanding. Is there any Iowa case law that deals with the personal reliance element of that statute that you're aware of?
Your Honor, I don't know that it's been disputed in court. Here's what I'm going to ask. I'm glad you're going to ask about that. Because in addition to the Illinois case, which makes it clear, and they explain why, and part of the things they point to, and I'll point it out with respect to Iowa, is how the statute is constructed. And what you do is you start out with kind of a presumption of common law requirements, intent, reliance, damages. And then when Iowa came and passed the original Iowa Consumer Fraud Act, because of the nature of it, and because it was solely enforceable by the Iowa Attorney General, they made it very, very clear. When you compare 714.16.2a with 714H3, right, compared to the AG statute, the private right of action statute, when you compare those two, they're starkly different. And the Iowa legislature in the AG statute, which was the one that was first enacted, made it very clear that it was disavowing certain common law elements, such as intent and reliance and damages. And the reason is very clear. So I'm sure your honors have cases. The Attorney General actually has the power to come in before somebody's been harmed regardless if the consumer is actually going ahead and rely on an act, even if the defendant may not have intended what was to occur. Because they come in and they can get injunctions and different kind of equitable relief. And that makes sense. They're an elected official, and that's part of the function. But when the Ohio legislature enacted the private right of action, it didn't do that. It left all of those elements in. And it's also made clear, Your Honor, by the relief sections, where the private right of action says there's got to be actual damages. And they have to result from the act. And not just the act, but the act that violates the statute. So the Illinois Supreme Court took the same language, and they said that's a cause. And that means you got to rely on it. And indeed, it wouldn't make any sense. If you didn't have a reliance argument, then this really, we kind of joked in our brief that we make it the Iowa Fraud Act, not the Iowa Consumer Fraud Act. It really is worse than that. We're just making a freestanding grievance statute. Then you get to damages, Your Honor. And this is important not only because it's an element of the claim. I mean, often we don't think about damages until later, but it goes to show the reason they're suing. It kind of sheds light on the rest of the elements. And if the private right of action is limited to actual damages that are an ascertainable loss of money or property.
From the transaction itself.
From the transaction itself.
Okay.
And so it's designed for people to go make their money. And when they were a project induced into a transaction that they shouldn't have induced into.
Let me ask you this. The difficulty, I'll be honest with you, that we run into in this case is the current procedural posture that we're dealing with. Is there sufficient pleading or lack thereof to allow this court to dismiss it on a motion for summary judgment, or is this the matter of damages really an issue that has to be dealt with on a summary judgment phase, not a motion to dismiss?
Yeah, and I'm glad you were asked that. And it can easily be dealt with and should be dealt with on a motion to dismiss, and here's why. Plaintiffs have been very clear about what their damages are and what they are not. They've been very clear that their damages are the time and resources to mitigate the influence of the Iowa poll on the election. Here's the problem. First, if it does not provide consequential damages, you don't get damage, you don't get mitigation damages. And you cannot bring a claim for contributions to a campaign or on behalf of a campaign, which is acceptable to the city, or losses by other third parties.
Is that because of the definition of consumer under the statute? Is that where you hang your hat?
Well, it makes clear that
let me just ask you this while you're thinking about that. Because the difficulty I guess I have in interpreting that any of the damages that were sustained, even if the plaintiff were allowed to amend to assert a claim based upon the campaign itself, consumer is defined in 714H.2 as a natural person or that person's legal representative. I don't think a campaign would fit into either one of those.
it would not.
So to the extent that there are any damages, they have to be damages that are actually incurred by the personal plaintiffs in this case, correct?
Exactly.
Based upon the transaction of buying the register to the extent they bought it, correct?
Correct.
And in the pleadings itself, it only indicates that only maybe Plaintiff Miller-Meeks was even one of the buyers of the register. Is that a correct statement?
That's absolutely correct. And importantly, Mariannette Miller-Meeks did not rely on the iron pull in purchasing it. That's not why she is a subscriber to the Des Moines Register. It had nothing to do with that, right? She just happened to be a subscriber of the Des Moines Register, and that's important. And so, what they've alleged not only is insufficient, but more than that, it makes clear that there can be no set of conceivable facts that would result in damages or any of the other elements. It just can't happen, right? We know who the plaintiffs are. There are three individuals, right? We know that it's about the iron pole. There are no set of conceivable facts that are going to meet these elements. Next, Your Honor, I will briefly talk about fraudulent misrepresentation and negligent misrepresentation. Three issues that I think are easiest to deal with on fraudulent misrepresentation are first, that the poll is not actually a statement of opinion. You have to have a statement of fact, something that's capable of being proved true or false. Clearly, the poll cannot be proven true or false. Opinion can be false. Plaintiffs certainly engage with that in the brief. There's no justifiable reliance that they allege or can allege here because they completely disavow. They plug themselves out of court, right? They completely disavow that. President Trump was very clear that he thought this was fake from the beginning. Lastly, regressible damages. Again, damages don't fit here. It's a little bit different damages that are provided under fraudulent misrepresentation. You're limited to out-of-pocket damages or benefit of bargain. They're not claiming benefit of bargain. They say, hey, well, I think we have out-of-pocket damages. But the problem with that is it's limited to a loss suffered as a result of recipients' reliance upon the misrepresentation. Again, they're not claiming that they're being damaged because they bought a newspaper here.
One of the things, Mr. Klinefeldt, and likely if you know otherwise, but I couldn't find, in looking at these cases that were cited, it appears that most of them were postured in a motion for summary judgment phase or trial or whatever, but I couldn't find any that, at least in my research, indicated that it was amenable to dismissal or motion to dismiss the case. And are you aware of any cases that support an action that early in the case?
Well, I think we truly have a unique set of facts here, Your Honor. And I think this is very similar to the INFA situation because it's a similar theory, right? It's fraud. And where you made clear that there's no way you can meet an element, it shouldn't matter, right? And so, for the same reasons why motion to dismiss is appropriate in any case, it's appropriate in a fraudulent misrepresentation case. The even easier one, of course, is negligent misrepresentation. And the only element I'll focus on here, to focus on the rest of the briefs, is, as Mr. Corn-Revere pointed out, in the Beattie case, I mean, there's no duty between the parties in this case that would result in an negligent misrepresentation case.
Let me ask you this. It's my understanding and recollection in trying cases of this nature for a number of years that negligent misrepresentation is pretty narrowly defined to just a handful of group of folks that would fit into that advisory capacity issue. Is that correct?
Absolutely.
Attorneys, the accountants, maybe some engineers, but even that is not, I think, a straightforward thing. Do you have any indication that there's any case law that would support similar background as what we have here, where the court has allowed a case like this?
No, we have not found one place. And so, and again, that makes sense because it would certainly be a reverse result. Because, it would mean pollsters would be subject to liability to anyone who happened to read the poll. It would mean that, people who forecast the weather would be liable to anybody who watched the news. It simply wouldn't make sense. Lastly, on the federal case, Judge Edinburgh, we would simply say yes, Your Honor. That is an extremely strong precedent. We don't think Your Honor needs to necessarily get into whether it was precluded, if there's an issue preclusion there or not. Judge Edinburgh was clear on how she defined the case. She described it as brought on behalf of all Des Moines Register subscribers, asserting this mistaken form of quote-unquote fake news constituting fraud upon the entire candidate class. Two things I think are important about that is the Beattie case was purportedly about consumer harm. It was kind of a classic case. You come in, I think there's consumer harm, class action, and everyone said, yeah, there's no claim here based on the item report. The second thing is, in terms of this being uniquely strong presidential authority, is these cases were filed within weeks of each other. It indicates that maybe not only let President Trump file this case first and Beattie comes or whatever, Beattie tried to even file his lawyer tried to file an amicus brief in favor of Trump on one issue. But the bottom line is it's the same defendants, same claims, same issue, same judge. And both motions to dismiss were briefed up before the decision on Beattie, and of course the judge noted they were related, and so she dismissed all those claims of prejudice. And for those reasons, Your Honor, for all the reasons that I mentioned here this morning, we request that the court dismiss plaintiff's lawsuit of prejudice.
Very well. Thank you. Before I turn to you, Mr. Ostergren, I think why don't we go ahead and take a break. Before I do, which one? Revere, I was mispronouncing your name. I apologize. I totally messed it up, so please forgive me. But why don't we go ahead and take a break? We'll come back on the record at 20 after the hour, and we'll pick back up that Mr. Ostergren. Thank you. We'll go back on the record, and I will turn to counsel for plaintiff. You may proceed.
Thank you, Your Honor. I want to emphasize, as the court knows, that notice pleading is Iowa's role. Defendants expressly or impliedly rely on federal pleading standards in their arguments. They want to be enrolled with Iqbal and Klinefeldt, but they are not. The pleading standards in those cases have been repeatedly, expressly, and emphatically rejected by the Iowa Supreme Court. The law is that all we have to do is put the defendants on notice about why they're being sued. And based on the motion papers and comments of counsel, they clearly understand why they're being sued. That satisfies the standard for a motion to dismiss.
But just before you get too far, but you would agree with me under 1.421F, it still has to articulate the claims, the elements of the claim, correct?
The Tercel Foundation case answers that question in the negative, Your Honor. And makes clear that the petition does not even have to fully specify the legal theory upon which it is based. That's a recent Iowa Supreme Court case dealing with notice pleading standards. Now, it is true it's possible for a plaintiff to plead himself out of court. That's what the case has said. But this happens when a plaintiff has made allegations that conclusively show he has no right to recovery. A good example would be a petition that clearly shows the case has been brought beyond the statute of limitations. A case that I'm litigating right now, where a plaintiff has filed a petition for writ of certiorari to challenge the decision of the Board of Supervisors acting in their legislative capacity. Where, of course, certiorari will not reach that. That is pleading yourself out of court, but that is not what has happened here. My friends have made arguments that would be very well done if we were here arguing a motion for summary judgment. Almost every single thing that they said, and frankly, almost every question that Your Honor asked, inherently depended on understanding what the facts are but what the facts are. And if at some point in the future we're back in this court and counsel have a stack of motion papers at the summary judgment stage, then we can meaningfully talk about whether there is a jury question here. But until we get to that point, almost anything that has been asserted cannot be resolved at a motion to dismiss stage.
Do you believe that is even the case when there is an issue of First Amendment? In other words, I guess one of the things that I struggle with in this case is the tension between that notice pleading and to what extent the First Amendment gives you protection. It seems like there would be a massive chilling effect if any case is allowed to get past the motion to dismiss phase for a defendant of this nature. How do I resolve that tension between the two, the First Amendment and the notice pleading?
Well, I think it's an insightful point, Your Honor, and we've had references to our new anti-SLAPP law. Now, a couple points on that I think address your question. If I have, please follow up and keep me honest on that point. First of all, in some of the motion papers earlier, there's been some complaining from the defendants that this lawsuit was filed before the anti-SLAPP law went into effect. Although later they don't have their cake and eat it too. That's I think maybe a mixed metaphor there, but they want the court to import some anti-SLAPP reasoning into a case where the statute doesn't apply. But for all the complaining that this lawsuit was filed before the anti-SLAPP lawsuit or statute, went into effect, it's interesting that essentially, according to the defendants here, that anti-SLAPP law was completely unnecessary. Because they say all of these cases can be resolved without the anti-SLAPP law being in effect, because the First Amendment can be waived out, and then the plaintiff is kicked out of court. Now let's think about what the anti-SLAPP statute does. The anti-SLAPP statute does not change the notice pleading standards in our state. The anti-SLAPP statute says that a defendant in certain kinds of cases can conduct discovery early and in a limited fashion on the issues that would drill down on First Amendment as an overarching legal principle touching certain areas of the common law or statutory law. And then you have a motion for expedited relief, which is essentially an early, quick summary judgment process, and then a right for appeal based on the district court's denial of such an early motion. There's nothing in the anti-SLAPP law, which of course does not apply to this lawsuit, that purports to change notice pleading standards. It simply flips the normal process of how discovery and motion practice works in certain kinds of cases. And so, Your Honor is correct. The First Amendment is an important thing. We believe that too. But it doesn't just simply eradicate common law theories of fraud, statutory theories that are built on fraud. And the First Amendment itself does not protect certain kinds of speech, and fraud is one of them. And we can't know the extent to which that exception applies until the parties have conducted discovery. That exemption, I shouldn't say exemption from the First Amendment or exception. The First Amendment, the freedom of speech that it protects, does not include certain kinds of things like fraud and true threats as examples.
Let me ask you this while you're on that subject in particular. What further facts would needed to be developed during the course of discovery? For instance, as I take the defendants in this case, they are contending, hey, this is all just a matter of law. There really aren't necessary facts that need to be decided. What, in your estimation, are the facts that need to be developed in the course of discovery?
Well, we need to know how the poll was conducted, whether a poll was conducted. We take it on just the simple assertion from the defendants that this was actually calling people and asking their views. What was the process when these flawed numbers were being considered and vetted? What was known and understood by the various participants in that publication process about the possibility that these numbers could be real? What decisions were made about going ahead in the face of information that was so utterly implausible that it defies belief that it could be anything other than deliberate misconduct? Just to name a few. Those are all things that we have to know before the court can start applying these doctrines. Much of this sort of just has happened in the vacuum as to what the court thinks the case is about. And respectfully, the court can't know that yet until we have a fully developed summary judgment record to see if there's issues that are in dispute. And I suspect there's going to be a lot of issues in dispute. And that means the islands are going to sit in that box and decide, not the court.
But from your standpoint, the 421, there is no heightened standard that should ever be applied in a situation where the First Amendment is under.
Not at a motion to dismiss stage under the law that applies to this case. And even if we were in an anti-SLAPP procedure, the remedy for that is early discovery on those questions and an early determination as to what facts are there, so the court can apply these doctrines with the First Amendment sensibility, I'll call it, that overarches how the court analyzes those things. So even in the anti-SLAPP court, the court can't just dismiss a case and say, oh, well, the First Amendment. If that's true, our law would be media organizations are immune from suit. They have sovereign immunity, essentially.
You know, it's my understanding you're proceeding under an argument that this speech was commercial speech. What discovery would be needed to flush out the issues relative to that? I mean, it appears that it's all in the pleadings.
Well, I think the discovery would flush out, much like I said before, was this actual polling that occurred? Or is it just contrived? I mean, that would be one aspect of it. Everything that led up to the commissioning, if the poll actually happened, if it did, how it was conducted, what data was presented, what assumptions were made in the process to reweigh the populations that were sampled. There's things that are done in that process in legitimate polling that can turn things into just fabrications. And so that just scratches the surface of what will have to be learned in order to understand, does this fit within a commercial speech doctrine, or is this just some statement of opinion that's protected by the First Amendment? We can't know that until we have gone through the discovery process, and then the court can be presented with a summary judgment record and decide, are there fact issues that have to be tried?
You referred to commercial speech. I want to drill down on that. I may be getting ahead for your presentation. I apologize. But while I'm thinking about it, I want to ask you. The argument that I understand you're making as far as this being commercial speech is, as I can tell, there's not a lot of support. It seems fairly unprecedented, for lack of a better way of putting it. Are you aware of any cases nationally, statewide, that would give us a good direction that a poll of this nature would be considered commercial?
Well, I will readily admit that there is a certain novelty to the claim that we are pursuing. As Mr. Klinefeldt, quite frankly, said himself, that this is a historic manipulation by a news organization, in our view, of abusing its position and putting a product out into the on the eve of a highly contested election, which all indications show was fabricated or to the point of such colossal mistake upon mistake upon mistake, and then pushed out the door, that becomes misconduct. And I don't know of anything like that that's ever happened in the history of our political and media system in that exact way. And so, yeah, there are no questions of law, in fact, that have to be explored.
But you believe that those novel questions are ones that require a matter of discovery and can't be resolved in this issue, with this.
And it's not just that I believe that, Your Honor, but I was in court has, frankly, warned defendants and respectively warned district courts over and over and over about trying to run in court and file motions to dismiss or granting motions to dismiss and causing an unnecessary appeal where, I mean, you know, Your Honor has read those cases too. The Supreme Court sends it right back and says, no, we meant what we said about those three. And I'll start this process and go through discovery and find out what the facts are.
In the normal course of a car accident or malpractice case, I would totally agree with you, but this case strikes me as it sits much different than a normal case because of the First Amendment implications, because of the procedural posture that it took before coming to this court. It gives me pause as to whether that normal course of application of 1.421 subparagraph F would apply in just a bare bones pleading is required. Specifically, because of the massive, just say it, massive First Amendment implications that are here, there is an element of chilling, and there is an element of that would come with that and require, I think, for Kane, that I should take a closer look than just a normal malpractice. Is that, am I wrong on that? Maybe we're going around in circles, I don't know.
Your Honor, respectfully, that sentiment doesn't come with, as the Iowa Supreme Court said in Doe versus Smith, our notice pleading standards change in cases that seem really big or really important or whatnot. And yes, do the defendants have First Amendment values that apply to them and they want to uphold? Yes. The plaintiffs in this lawsuit also have interests to be able to run for office without this kind of rank manipulation of the process, to communicate to voters. I mean, if you want to pull the lens back, I would say you're going to encompass a wide field of view that doesn't just look at the Des Moines Register. It looks at millions of Iowans, hundreds of millions of Americans, people around the world who were, I'll just say, deeply disturbed by the conduct and misconduct of these defendants. We all like to say every election is the most important one that we have ever had. I think most people would say the 2024 presidential election is a fork in the road. And there may be many forks ahead. Who knows? But to have that lie dropped in the middle of our political process. If the court wants to say, gosh, you seem like big important issues here, and I have discomfort, then you have to put that on the ledger too. And what all that says is that this should be aired in a court proceeding, not a court just simply saying, Yeah, that was really bad, but I think these media defendants should get a pass. And it doesn't matter what those police standards are in the state of Iowa. It doesn't matter what the Iowa Supreme Court has said over and over again. I don't like the lies, therefore case dismissed. That's, Your Honor, I appreciate you asking the question when you did. But that's not law.
Okay.
So, on the question of actual damages, the consumer fraud statute doesn't say you just get the price of your newspaper you bought that day back.
No, but it does tie to the transaction of the damages, correct?
Well, forgive me for my Actually, 714, capital H.2, sub 1. Actual damages means all compensatory damages approximately caused by prohibited practice or act that are reasonably ascertainable in amount.
Okay.
It excludes non-economic damages, is what the definition essentially says. Okay, so they have to be pecuniary losses, but it's not. The legislature wanted to say a disgorgement of the transaction, a reversal of the transaction. They could have and would have very easily said that.
Now, let me ask you then the question that I asked and posed to Mr. Klinefeldt. Under that statute, back up. Assuming for a second that your clients suffered an economic loss, the pleadings seem to indicate that that economic loss may have run to the campaigns and not to the individuals. And to the extent the individuals had any damages that were non-economic in nature. Am I misreading the pleadings?
I think you're reading it too narrowly, Your Honor, and part of this is the interaction with how both Iowa and federal campaign election law works, and that is if you are a candidate, obviously you run as a natural person, of course, but everything you do through the campaign has to be done through an official campaign committee. And I would take the position that that's your legal representative for engaging in the political process.
Are you aware of any case law in Iowa that would define legal representative that extensively? Does it do it in the campaign finance world? I don't know.
Well, in terms of, no, I don't know if anybody's ever litigated that question in the consumer fraud.
I'm fairly certain to have.
I'm doubly fairly certain. So, but as a question of how election and campaign finance law works, the law says, in effect, you interact with the process through a single committee with a responsible treasurer with all the dollars connected with the campaign effort. There's a couple of tiny little nuances to that. I'm going to leave off, if you're running for office and you spend less than $750, that don't apply, okay? Some little nuance, but basically, everything has to be done through that official committee in how you participate in all the nuts and bolts of running for office. And so, there's no additional information in the statute as to what legal representative means or doesn't mean. And I'm sure that would be an issue that's faced with vigorous motion practice. But I don't think it is just simply President Trump and the other plaintiffs alone simply as like what was in their pocket when the poll dropped. That is a far too narrow view of the scope of the damages.
But humor me for a second. If it were a matter of actual damages suffered by the individual plaintiffs, in this case, not the campaign, where in your petition have you asserted that they have suffered any economic damages?
Well, in the part that you refer to, and because I know how federal and Iowa election law works, I think it's very hard to separate the candidate from the official committee. Because
I'm sure election law is separated too, correct?
well, not really. I mean, you have to have your whole operation within a single committee if you are legally obligated to create and structure disclosure requirements, and you can't do anything outside of that legal representative that you're forced to create to engage in the vote process. If you want to spend more than, I think it's $1,000 on a process, which that's possible in that.
Let me switch gears a little bit. I don't want to take you too much about your presentation, obviously, but I do have a question. Let's talk a little bit about in the consumer fraud section. What you believe is the consumer transaction in this case that supports the pled that supports this cause of action? What would the consumer transaction be? Is it the purchase of the papers? Is it what is it?
So, you asked that question in a summary way, but I want to go back to what 714H.3 defines a prohibited practice to be. And it's making the false statements in connection with the sale of consumer merchandise.
Okay.
And then we have to show that the damages are caused by that sale.
Isn't there, I think the case law, I want to say it's McKee, maybe. The case law does indicate, doesn't there have to be some privity between the parties?
That's the Illinois case.
Oh, yeah, I believe so, yes.
That case says that. Whether under these facts, under this definition, and interpreting the statute, a privy relationship would be necessary. I think it's an open question.
Wouldn't that then, if there is no privity, we get back to the issue that they brought up in the briefs, and Mr. Corn-Revere referred to, doesn't that open up massive amounts of liability to people like meteorologists, sports commentators, this whole group of folks that are out there giving their opinions based upon their best guess, that somebody goes out and makes a bet based upon, and they plan their wedding based upon a meteorologist? Doesn't that open all of those individuals up for liability?
I don't think so, as proven by the fact that we don't see those cases being brought. But
just because nobody's been brave enough to break doesn't mean they won't come now.
I think the difference is in the type of misrepresentation made with the poll versus what any reasonable person watching the weather would understand as the zones of uncertainty and what is being forecast, and one's life experiences that the weatherman might say it's going to be sunny, but you should still bring your umbrella. Okay? Versus saying we have determined some objective scientific fact, which is just wildly false. Okay? And let me give you an example of that, Your Honor, in a different context. Okay? And quite frankly, I'm old enough to remember when a former Des Moines Register editor got involved in something very similar to what happened here. Okay? The court might recall this. In 1993, NBC News aired a news program about General Motors pickup trucks, claiming that they were defectively designed and would explode in crashes. And they staged for that news program a demonstration test crash, where they showed a vehicle striking the pickup truck and explodes in a ball of flames. shocking video that they put out. And it was later discovered that NBC News had rigged the truck with pyrotechnics to make the explosion happen. Okay? And I remember what happened to that former Criminal Register editor. He resigned in the aftermath of all that. NBC paid money and was forced to apologize. Okay? This is creating what is purported to be an objectively true fact. We have measured this population and we have gotten these answers, and that says X.
But, so how can you say that it's a fact when it's anticipating something in the future? And in the poll itself, there's a built-in error rate. They're actually saying this is what we think, and look, we may have this degree of error in it. How is that an objective fact?
Because it is so statistically improbable that measurement that they claim to have made, and we have to take it at this point on their assertion that they actually called people and actually asked them questions and didn't just concoct this. That's what discovery will tell us what happened with the polling process. And did so also with a congressional race that was equally wildly off. When I'm confident we're going to learn from the discovery process that every Des Moines Register political reporter would be telling their editorial team, we don't see that this is Harris +3 in Iowa. What are you talking about? Or words to that effect. And so that's when you get into it is objectively false. It is rigging the truck with explosives.
But doesn't that go to your additional point of reliance that the defense brought up? There's no ability, you in your own pleading spend a fairly significant amount of time talking about how the polls previous to this one were not reliable. And you guys knew about it, and President Trump, immediately after it being released, talked about how it was garbage. So how can you say that you relied upon this in any way, shape, or form?
Well, first of all, that reliance issue comes from that Illinois case. Right, and so certainly for purposes of today, I don't think the court can read into a reliance on that we have to plead the Twombly and false hands. Right? And this may be a good example of why courts can look at what the statute says and not add elements to it. And we have to show causation to understand that for damages. But I'll go back to the example I just gave you there. Right, obviously GM would not have been relying on NBC News in that situation. What you have is a news organization creating a lie, and then people damaged terribly trying to deal with the consequences of that 3 days before Election Day. Did you have Your Honor, any other questions?
No, I don't.
One more thought that I want to end on that. And I want to respond to my friend Mr. Corn-Revere's comment, first of all, raised in a reply brief, which is not where you bring up new ideas. So, and he brought it up again today that somehow the court should sui sponte issue sanctions to us, or issue order, show cause, or whatnot. We discussed this thoroughly at the last hearing. The Iowa Supreme Court Shearer case is quite recent and explains lawyers are allowed to bring novel claims. As Mr. Klinefeldt says, this is a novel claim. You're right. We are allowed to do that. We're allowed to ask the court to revisit prior doctrine. We're allowed to ask the court to find that the Illinois case on the line is not applicable here. We're allowed to do all those things. And I'll remind my friend that he appears in his courthouse within pro hac vice, and he is obligated to act like an Iowa lawyer when he does that. And I don't want to be in a position where I have to ask this court to revoke that admission because he's not acting like an Iowa lawyer would act. And I hope this is the last time hear about this. With that, Your Honor, we ask the court to deny the motions.
Thank you very much. Appreciate it. And with that, I'll turn back. I guess I'll just loop back around. Mr. Corn-Revere, if you would like to give any rebuttal. Take your time.
Thank you, Your Honor. Just a few points in rebuttal. I want to start with the point that Ms. Rossi first brought up, talking about how the anti-SLAPP standard doesn't apply in this case. And we would agree that it doesn't, but it's something that the court can take into consideration. But in making that argument, Ms. Rossi fundamentally misstated what the anti-SLAPP law does. It made the argument that it didn't repeal those things. Simply said special rules of discovery and special summary judgment. In fact, what the anti-SLAPP law does is create a motion for special expedited relief. The person in the civil claims file may file a special motion to dismiss based on this act. The motion stays discovery and requires the court to conduct a hearing within 60 days of filing. Now, isn't that kind of interesting that we're arguing that that law is necessary to dismiss on a simple motion to dismiss? And the fact is, states around the country and now Iowa have passed these anti-SLAPP laws to make it absolutely clear that those special rules to apply. But that doesn't get a pass in a mostly state that does not have anti-SLAPP law to accept deficient legal claims. They are still barred under anti-SLAPP principles. In terms of those, we cited a number of cases in our reply brief to talk about notice pleading and dismissals that were appropriate specifically at the notice of the motion to dismiss stage. For example, White v. Cartwright dismissed 6 out of the 6 claims only one survived. And the Iowa Supreme Court said in that case that dismissed it as proper when a petition shows the claim requirements are legally deficient and the plaintiff has no right to recover as in Iowa law. Now, in fact, the plaintiffs did cite the White case in their papers and cited the victim in the dissent that said that dismissals should be rare under this case, but ignored the holding of the case, where the claims in that case there was some constitutional claims and some tort claims where they were deficient. The court dismissed the claims, and as a matter of fact, where the district court had not dismissed claims on appeal, those dismissals of those failures to dismiss were overruled because they should have been dismissed. Or you could look to Belin versus Kawasaki Motors Corporation, where the Iowa Supreme Court said that notice does not create a duty that otherwise would not exist. And Schmidt versus Mahoney on that same team said that case must be dismissed, where there is an absence of legal duty that precludes recovery, as here. Schmidt versus Drake University, it was not created by the statutory remedy. It must be dismissed where there is no private statutory remedy. This is the legislature provided. Or Smith versus don't have a claim, notice that dismissal is required. And in Kingsway versus Cathedral, which is Iowa Department of Transportation, the Supreme Court said, where the petition's own allegations show no legal right to relief, the court must dismiss its claims. So, contrary to what we hear from the plaintiffs, dismissal is required, and that includes claims for fraud. So, for example, we cited Postal Finance Company, which is Langford, where the Iowa Supreme Court affirmed dismissal and explained that to call in fraud without stating the facts constitute fraud is not an issuable allegation. And so that's the argument we can make. Mr. Ostergren said we've been trying to rely on federal standards. That simply isn't the case. We cited the Iowa group, acting like Iowa record, and we that the basis for dismissal is complicated. The third thing is that listening to Mr. Ostergren talk about the basis of the claim, what they would find in the discovery, what facts would make it necessary for this case to go on. All of them are geared toward saying that we will find out just how wrong this whole was. We'll find out how it was created, all that. In the very premise of our motion case, even if you accept the conspiracy theories, even if you accept the wildest allegations that these people are willing to make, there is no claim here. None that can be recognized to go forward. And it doesn't matter how much discovery you were to allow, or how many ways they're trying to make a complaint. You can't fix what is irrevocably broken. A good example of that, looking at just the First Amendment factors, is a case that we cited in our reply, Flagg versus the New York Times. That was a case where an author had sued the New York Times for a trade libel, among other things, because he was upset that the New York Times excluded him from its bestseller list. And the allegation was made that that injured him because he didn't get the respect that he was due. The problem was his pleadings didn't include the necessary elements to make a libel claim. One of the necessary elements is that someone has to issue a statement, a false statement of and concerning the claim. The problem in that case is there was no statement. The plaintiff wanted the New York Times to talk about it, and that was the basis of his claim. The California Supreme Court called the dismissal and said that it was absolutely barred under the First Amendment because the basic elements of the case could not be made. And the same is true here, where no matter how false Mr. Ostergren has convinced himself the quote is, or how nefarious the motives behind it, it simply is not a claim that would be recognized under the First Amendment. Again, Mr. Ostergren tries to rely on the commercial speech doctrine, but again, even fuzzes that, because commercial speech, even if you accept that that was a doctrine that applies, and it doesn't mean that speech is unprotected by the First Amendment. He would still under his fraud claim separate it, and it simply doesn't apply. You may recall that I asked Mr. Ostergren to cite his best case for the principle, and I'm still waiting for that case. There simply isn't one. The drawing I asked earlier about the starting networks and whether or not that is the proposition that the commercial speech doctrine might apply here. And if you read the rest of the quotes, beyond the ones that you see in the plaintiff's papers, the Supreme Court says we begin with several propositions that are already settled beyond serious dispute. It is clear, for example, that speech does not lose its First Amendment protection because money is spent to protect it, as in a paid advertisement or advertising form or another. Speech is likewise protected, even though it's a carrier form that is sold for profit. So, none of these arguments add up to kind of cognizable claim. And again, everything that Ostergren was saying was just how bad he thinks this poll is. But the point is, that doesn't make it fall into a category of unprotected speech. And that was the point of the Eighth Circuit drove home in the arson cases, saying that even in a political context, even when people may rely on statements being made, you simply cannot, under the First Amendment, make it an offense, either with criminal law or that civil law, to tell a lie in a political campaign context. We also cited at page 13 of our motion states, various states that have had laws that attempted to do that kind of thing, all struck down. In Massachusetts, North Carolina, Ohio, Massachusetts, and Washington. All of those states regulate the very interests that Mr. Ostergren is trying to champion, all not allowed to go forward. And that is the problem of trying to mix and match various documents. The problem of trying to create claims that they don't otherwise exist. There simply isn't a recognized category of First Amendment speech that courts will allow a claim like this. Like I said, I asked Mr. Ostergren to name this case. It really has come up with nothing. And what you find are isolated statements from a handful of cases saying that falsity isn't protected. As I've noted when we discussed that length in our briefs, that's true only in specific contexts. In the defamation context, and this is in a defamation case. It's true in the fraud context, and for all the reasons that we've laid out, it doesn't meet the elements of fraud, which are constitutionally required according to both Madigan and Alvarez. None of this adds up to coherent theory. In Alvarez, the court explained and took statements out of one area of free speech law, plug them into another, and make them apply. And honestly, specifically, said that fraud principles, that the objective of this attempt to apply fraud principles to all knowingly false speech in the electoral context. Your Honor, we just received a decision this week, and I apologize we didn't have a chance to cite it in our papers because of it when we came out on Tuesday. But it's a decision not on these issues specifically, but on just general First Amendment theory, this time in protecting university speech. The case is Grinnell versus Florida Board of Governors of the State University, and that involved the state's attempt to control the curriculum in the state. The court castigated the state for pulling various quotes from doctrinally unrelated areas. And it said this: Florida seeks to obey any First Amendment limitations at all by bringing together several speech doctrines to create a new rule that would quietly remove all free speech protections from the classroom. The Florida defendants did not put together half a donkey and half a camel and then ride to victory on the synthetic hybrid. That's exactly what's going on here. That's why plaintiffs have not been able to name a single case that would support their theory. That's why they have not responded at all to the various attempts that have been made to bring fraud claims against against news organizations, because they simply don't make out claims that fall into the recognized exceptions. Finally, let me just address the issue of sanctions, because again, Mr. Ostergren has said that I'm, as he put it at the state here, waving the bloody shirt, talking about sanctions. It's interesting because the origin of that expression, waving the bloody shirt, comes from a congressman from the 1870s, Congressman Benjamin Butler. And the expression came from what he would constantly wanted to support a weak political argument, talk about all the sacrifices of our Union soldiers. And so he would wave a bloody shirt, I don't know if that figuratively or literally, to try and cover up the weakness of his claims. And that more or less describes the nature of this case. We hear lots about fake holes and all of that. When in fact, plain fact is there is no legal argument to here. And that's the whole point of raising the question of whether or not professional responsibilities have been met in this case. This isn't something that just came up to us in a reply as Mr. Ostergren suggests. This is something we've been asking for from the day this case was filed. And in fact, before the day this case was filed, because we asked the same question when this case was in federal court, we made the point in our motion that they have made no argument for extending the law. They're simply ignoring the legal argument, saying they don't acknowledge what the existing law is, let alone make an argument to change the law. And that's something that we pointed out in our reply brief, saying you still haven't come up with a case. And if you want authority from Iowa on that point, Barnwell, which is the Iowa District Court for Polk County, that I mentioned earlier, is the correct authority, where it not only says that there is an obligation to acknowledge this law, is trying to provide some response to it, but it also upholds sanctions when someone tried to make a claim for negligent misrepresentation where there was no duty between the parties, just as there is here. So again, I'm not asking for sanctions, but I would like an explanation, and I think the court is in a position to demand one. Thank you.
Thank you very much. Appreciate it. That, I'll turn to you, Mr. Klinefeldt, for last one.
Thank you, Your Honor. I'll be brief. First, to address the novelty of this case, unfortunately, it's novel in the sense that it's being brought by the President of the United States against the state's largest newspaper, but it's not novel in the sense of politicians attempting to intimidate the media in our history. That happens, unfortunately. And there's been case law, and I think Mr. Corn-Revere has cited much of it, that has dealt with that. The other thing I want to say about the First Amendment is really two things. One, I think we need to take a step back and realize that this is a fraud case based on political speech. That's a problem. That's unconstitutional. You can't do that. Iowa's notice pleading standard does not supersede the Constitution. This is not commercial speech. And even if plaintiffs want to turn that page and go down that road, they've said nothing about this being limited solely to a proposal for a consumer transaction.
Yes, please, Mr. Klinefeldt. Is the fact that, as Mr. Ostergren has argued, that they're alleging that there's manufactured data or non-existent data, at this juncture, I assume I have to take that at face value, have to assume that allegation. Does that affect the analysis at all with the state claims?
Absolutely not. It does not turn the iron whole into a proposal for a consumer transaction. It does not magically create a consumer transaction. It simply doesn't happen. I want to address briefly a couple of questions that Your Honor asked my colleague. One specifically was on infant images, and I just want to see if I can help out on that issue. And the question was twofold. One, plaintiff's counsel seems to be indicating that all pecuniary damages are available under ICFA. He doesn't, in other words, he doesn't deny that the damages they're asking for are in the nature of mitigating those are provided for in HIPAA. They're not. The law is clear on that. It's actual damages, court knows what actual damages are, it's defined. That's a legal dispute. It's not a summary judgment dispute. We're talking about how much damages are. This is the nature of damages. That's just not.
It's actual damages and excluding non-economic damages too, correct?
Correct, absolutely. And that's actually the second brief point I want to touch on that is there's a question about legal rep and campaigns and what the statute actually says is legal representative of a natural person. All the statute's talking about, Your Honor's probably been through this before, is they're talking about a legal representative for a minor or a deceased. They're not talking about a legal representative for a separate legal entity like a campaign or something like business.
Or an agent.
Or an agent, exactly. Next, Your Honor asked about consumer transaction. And again, this exemplifies why we're talking about a motion to dismiss here, in that plaintiff's counsel does not say there's going to be a consumer transaction, that there was a consumer transaction, that the discovery could produce one. Saying it's not required. That's a legal dispute. It absolutely is required. We rest on a brief there. But if it wasn't required, again, you just have a freestanding grievance statute. But that's the legal dispute, whether or not that's required. Not what the facts show or could show, but whether it's required. Lastly, Your Honor asked about what discovery plaintiffs could anticipate would change the case. And the answer is, well, how the poll was conducted, whether it was conducted at all, the process in which it was conducted, what the participants knew or understood. What it would not change is it would not turn the average poll into a proposal for a consumer transaction. It would not demonstrate that there was a consumer transaction. It would not demonstrate that there was reliance on the accuracy of truth of the poll to enter into a consumer transaction. It would not establish legally cognizable damages. At the end of the day, Your Honor, I think what we've all collectively demonstrated to you today is that there's no conceivable set of facts that could make out a legally viable claim. Thank you.
Thank you very much. Thank you, folks. I appreciate the presentation. Obviously, you've given me a lot to think about, a lot to plow through. I'll get you out in order on this as soon as possible. It is going to take several weeks, I'll be honest with you. I've got a number of other rulings I've got to dispose of before I'm able to handle this one in earnest. So please bear with me on that end. I will get you out, though, as soon as I can in order. It will take a little unlikely to be as long as you're proving. But I'll get you out when it's possible. Thank you so much for your time. We'll go ahead